Should just switch.
Okay. Is the red thing just says REC?
Yep.
All right.
All right, good afternoon. Thanks for the awesome turnout. This is the ice storm. I know it's difficult just even walking around outside. It feels like you need ice skates. But of course, we welcome you to today's event. It's on Native American tribal law and federalism. My name, of course, is Zaman Sharma. I'll give the brief introductions to our speakers. Today's event is a speech with commentary. So Mr. Tom Gede, he's our guest speaker today, will be speaking for about 30 minutes or 45 minutes, and Professor Charlie Wilson will be giving a commentary afterwards. Mr. Tom Gede is a principal in the Bingham Consulting Group and is of counsel to Bingham Hutchinson LLP. He resides in the San Francisco area and works in the San Francisco office. He's worked as the executive director of the Conference of Western Attorneys General, where he coordinated activities on legal and policy issues, including energy, environmental, water law, public lands, and telecommunications with the Attorney Generals of 18 Western states and territories. He's also worked in the California Attorney General's office since 1987, and he maintains an intimate knowledge about the workings of the AG's office. He's testified before Congress and the California legislature, and we brought him here largely because he's the Federal Society's expert on Native American issues. Mr. Charlie Wilson earned his JD from NYU before going back to clerk with Chief Judge David T. Lewis at the U.S. Court of Appeals at the 10th Circuit. He then practiced with the New York firm of Sullivan and Cromwell. Here he teaches labor law, advanced labor law, employment law, legal negotiation and settlement, civil procedure and evidence. His works in progress include books on the Ohio Rules of Civil Procedure and the Ohio Public Employee Collective Bargaining Act. I should mention that Professor Wilson has bravely come out to do a commentary. We know his expertise is not actually in Native American legal issues, but nonetheless, we're very proud to have him with us today. Please join me in welcoming first Mr. Tom Gede.
Thank you very much. Thank you, Aman, and the Federalist Society of the Ohio State University Moritz School of Law. It's a pleasure to be here. How many of you have studied federal Indian law? Show of hands. Lots of you. Come on. Okay. How many are tribal members? Any tribal members here? Anybody with Indian blood, as you see it? Okay. Good. I'd like to address federalism and the role of the American Indian tribes. It's a field that remains muddled and where clarity is not likely forthcoming. And what a day to discuss federalism. Yesterday, as you may have seen, Judge Vinson ruled that the individual mandate in Obamacare is unconstitutional. And while he found the Act's expansion of Medicaid not coercive to the states, he did find that one, the individual mandate exceeds the congressional powers to regulate interstate commerce, and two, that the individual mandate exceeds congressional prerogatives to enact laws that are necessary and proper for executing its delegated powers, and thirdly, that the individual mandate is essential to the functioning of other critical components of the Act, and therefore not severable, and therefore the entire law must be overturned. This is bound to go up, where multiple circuits will rule, and as Attorney General Rob McKenna of Washington State has stated, it may result in one of the most important federalism cases in our lifetime. I don't know if that overstates it. I thought that Seminole Tribe versus Florida, upholding the state's 11th Amendment immunity from suit, was the most important federalism case, and others thought that New York versus U.S. was, where the federal mandate to the states requiring that they compact with each other for the disposal of low-level nuclear waste was an act that commandeered the state in violation of the principles of federalism. Incidentally, that analogy did not apply for Judge Vinson as to the expansion of Medicaid. The states claimed, the attorneys general that sued Obamacare claimed that that expansion of Medicaid was a commandeering of the states. So while Judge Vinson didn't buy that argument, he bought the others. And probably one of the most interesting is the necessary and proper clause application, where there, in his view, is no predicate for predicate power for the individual mandate in Obamacare. So keep your eyes on that. It's a very interesting time to look at the federalism issues and the Commerce Clause issues. In our federalist system, how many governments do we have? In U.S. versus Kagama, the Supreme Court noted, Indians are within the geographical limits of the United States. The soil and people within these limits are under the political control of the government of the United States or of the states of the Union. There exists in the broad domain of sovereignty but these two. Cited approvingly by the Supreme Court in Oliphant versus Suquamish in 1978. Other U.S. Supreme Court cases have stated forthrightly that there are three sovereigns in the United States. The United States, the states of the Union, and the Indian tribes, as Justice O'Connor has put it. I would submit to you that both statements are true, and let's get to why. In the world of tribal politics and policy, two issues, among many others actually, are the hot, charged third rail, and they are sovereign immunity of the tribes, sovereign immunity from suit, and Oliphant's prescription on tribal jurisdiction. This is Oliphant versus Suquamish in 1978, that declared that tribes do not have inherent power, inherent criminal jurisdiction to prosecute and punish non-Indians. Recently, I was privileged and honored to be appointed to the Tribal Law and Order Commission, and a part of the Tribal Law and Order Act. President Obama signed into law this last summer. There are some presidential and congressional appointments, and Speaker Boehner put me on. I believe the commissioners are all level, reasonable persons, and we're going to study and try and tackle the troubling issues of public safety on Indian lands in the country, where the statistics show a very troubling higher rate of domestic violence, rape, serious and violent crime occurring in Indian country, and that clearly needs to be solved. But there's this overlapping layer of jurisdictional claim as to which jurisdiction gets to prosecute and punish offenders. And that complex, convoluted layering of jurisdiction, you actually need a matrix to figure out. In federal Indian law, we do this. We build a matrix to show who has jurisdiction based on who the perpetrator is, who the victim is, whether it's on Indian country, and whether it's a public law 280 state or not a public law 280 state, and all of this. So it really is a patchwork. However, there will be pressure for us to mostly demands from tribal advocates to recommend overturning Oliphant, which is 1978, and I'm sure we will hear this at the commission level, to allow tribes to punish, prosecute and punish non-Indians. Many crimes that occur on Indian reservations the perpetrators are non-Indians. Now, whether doing this will solve crime on the reservation is an unknown, but there's no question that Oliphant is offensive to tribes. What is interesting about the hot third charged rail of Indian law, politics, and policy is that they are all characterized by one thing in common: the tribe's relationships with non-Indians. With the advent of Indian gaming, new commercial opportunities for tribes, urbanization, globalization, everybody's got an iPad, right? And intermarriage between Indians and non-Indians, the interaction between tribes and the non-Indian world has exponentially increased. Still, there's a wide spectrum of views as to what tribal sovereignty means and how it manifests itself and how it interacts with our federal system. From tribes with enterprises that are fully engaged in the non-Indian world and running a government that would be familiar to most non-Indians, to traditional societies holding on to traditional lifestyles from the American Southwest to Alaska. But no one contests that whatever the residual body of sovereignty that tribes enjoyed before, the United States founded nationhood, inherent sovereignty of those tribes has diminished, as Chief Justice Marshall explained in the trilogy of Indian cases from the early 19th century, so that Indian nations are really more properly denominated domestic dependent nations. That clause, that phrase, dependent domestic nations, is still the law. It's amazing in the field of law, as you're in law school, that you can take a class in which cases decided in 1831 and 1832 are still the clear federal common law of the day, cited and argued with regularity in every federal Indian law case of all jurisdiction. Domestic dependent nations incorporates a whole bunch of ideas. Domestic because they're within the geographic boundaries of the United States. Dependent, they're in a trust relationship with the United States. The United States has exercised a duty of protection to the Indian tribes, which is actually based on a familial relationship, which is why you heard of the Great Father, or the Father in Washington. The relationship, as tribes saw it, was one between brothers, or one between a father and a son. Women didn't get included in this, but that familial relationship formed the bonds that were the foundation of treaties, but also the notion of dependency. Nations, sovereign entities, called nations, but now that under the jurisprudence and under the trilogy is reduced to control over their own members. But they're more than associations, more than municipal governments. They are, because they were extra-constitutional, pre-constitutional entities that are sovereign to their own nationhood. Which brings us to, where do Indian tribes fit within our federal system? The formulation offered by Chief Justice Marshall in the trilogy has not changed in almost 200 years. We are no better off where he split the baby. Tribes are neither wholly sovereign nations nor completely subject to the complete jurisdiction of the federal and clearly not the state governments. As I said, they are extra-constitutional. They're really pre-constitutional entities. These questions come forth in full strength when we examine Oliphant and related issues addressed by the court in Duro v. Reyna and United States versus Lara, all of which tend to involve the doctrine of double jeopardy. And there's a reason for that, because double jeopardy tenders the issue of dual sovereigns, and who is a sovereign? And that's important to our question of federalism. Now, I don't intend to be the apologist for Oliphant, but Congress has actually acquiesced in its holding for 33 years without ever delegating to tribes or declaring that tribes have inherent authority to prosecute and punish non-Indians. Critics of Oliphant fault the court's recitation of history, its reading of treaties, statutes, federal practices, and opinions, and point to understandings that tribes did have as part of their reservoir of retained inherent powers, the power to prosecute and punish non-Indians. The truth is, the court in Oliphant envisioned that Congress could grant power to the tribes to punish and prosecute non-Indians, but that would be a delegated power. The argument made by the Supreme Court, the reasoning used by the Supreme Court, was that referring to the 1830 treaty with the Choctaw Indian tribe. The Choctaws, at the conclusion of their treaty, expressed a wish that Congress may grant to the Choctaws the right of punishing by their own laws any white man who shall come into their nation and infringe upon any of their national regulations. And then, as then Justice Rehnquist said, such a request for affirmative congressional authority is inconsistent with the belief that criminal jurisdiction over non-Indians is inherent in tribal sovereignty. Now, the next flashpoint came, well, let me go back to that. Such a power granted by Congress to an Indian tribe to punish and prosecute non-Indians would have to be a delegated federal power, which would raise this issue of double jeopardy. Double jeopardy, as I said, is central because it relates to the process of the powers of separate sovereigns. We have to examine, is the tribe using its inherent power as a separate sovereign, or is it using delegated powers given to it by the federal government? In the case of United States versus Wheeler, the Supreme Court said, as it related to a tribal measure, that the tribe exercises inherent power, the power that it held and retained before the American nation came along, in prosecuting and punishing one of its own members. Well, the obverse of that, or the reverse of that, is when you have a non-Indian facing a tribe. And if a tribe is to have the power to prosecute and punish a non-Indian, that would have to come from one of two sources, either a delegated federal power or its own power. And in Oliphant, the Supreme Court said it does not have the inherent power. The only way it can get it is through a delegated power. The next flashpoint in all this came when the court examined the question of whether tribes could punish and prosecute non-member Indians, viewed pretty much as non-Indians for these purposes, in a case called Duro v. Reyna. The court again articulated inherent tribal sovereignty does not include the power to prosecute and punish an individual who is not a member of the tribe, relying on then settled jurisprudence that a tribe's inherent powers really only go to their ability to govern themselves and their members. Remember I said, they're a nation, they're a sovereign, they're not like an association of members. But that's how the trilogy read it, that the inherent power really only goes to control themselves and their members. Justice Kennedy, writing for the majority in Duro, said that Oliphant provided the analytic framework for the case and proceeded to note that in Wheeler, that other case involving a member, the retained sovereignty of the tribe is that needed to, and this is the operative language, control their own internal relations and preserve their own social order. Well, that's a pretty narrow view of what Indian tribes are. That Indian tribes are sovereigns that control their internal relations. Implicitly divested from their powers is external relations. At least certainly they can't form alliances with France and Spain and Mexico. And that was a concern to the founding fathers. Beyond that, the tribe has been implicitly divested of all those powers other than that internal control. But the real message of Duro was Justice Kennedy's characterization of the powers at issue. He said, criminal trial and punishment is so serious an intrusion on personal liberty that its exercise over non-Indian citizens was a power necessarily surrendered by the tribes in their submission to the overriding sovereignty of the United States. Now this uses language that harkens back to the trilogy and the earlier jurisprudence, but is sometimes offensive to the tribes. Indians, he says, like all other citizens, share allegiance to the overriding sovereign, the United States. A tribe's additional authority comes from the consent of its members. Consent is the operative word there for Justice Kennedy. And so in the criminal sphere, membership marks the bounds of tribal authority. So you have this vision of membership being the bounds of tribal authority. And important when you're looking at the jurisprudence going forward is Justice Kennedy is still on the Supreme Court. And Justice Kennedy articulated that, as far as he's concerned, criminal trial and punishment is so serious an intrusion on personal liberty that these questions are tendered. So anytime a tribe asserts the authority to prosecute and punish, i.e. intrude on personal liberty, that is so serious, a non-Indian, certainly Justice Kennedy in future cases will find this very troublesome. Now, that whole proposition was viewed as hardly remarkable by one element, and as highly controversial by another element in federal Indian law, policy and politics, the community that follows these issues. Pressure mounted immediately in the Congress to grant, that would be a delegation, or recognize the inherent authority of tribes to punish and prosecute non-member Indians. Indians who are a member of another tribe, but not of the tribe that is punishing and prosecuting them. Congress enacted the Duro Fix, it was called, shortly thereafter, declaring that it recognized and affirmed the inherent sovereignty of tribes, their jurisdiction to try all Indians, members and non-members included. In short order, a double jeopardy case arose, testing whether Billy Joe Lara, this is United States versus Lara, a member of one tribe, having pled to a crime in another tribe's tribal court, would be subject to a subsequent federal prosecution. You got your classic double jeopardy question. If the jurisdiction exercised by the tribe over the non-member Indian, Billy Joe Lara, was the exercise of a sovereign of its inherent powers and not a delegated federal power, then the dual sovereign theory would apply and there would be no double jeopardy bar. Each sovereign has the right to prosecute that crime. The court in Lara upheld the Duro Fix with a very novel piece of reasoning. The Congress, they said, in the exercise of its plenary power relating to Indian affairs, simply relaxed, that's the word they used, the restrictions on tribal sovereignty, adjusting the metes and bounds of inherent tribal jurisdiction, using a property law term relating to the jurisdiction. And so they relaxed those restrictions and thus allow the jurisdiction to punish and prosecute a non-member Indian. Now, that was their novel reasoning in the majority opinion. There are some interesting concurrences, and that's where I'll finish off. Justice Thomas concurred in the result, but in a very interesting statement in which he said, what is this? Are Indian tribes sovereign, or are they not? He really questioned not only the reasoning in the court, but the whole direction of federal Indian law in this country. Because Lara didn't contest his tribal conviction, he had pled and was convicted in the tribal court. All that is at issue here is whether the subsequent federal prosecution was barred by double jeopardy. But he noted, just as Thomas did, that the majority didn't follow the right constitutional analysis. The Constitution, he said, nowhere grants Congress the power to adjust the metes and bounds of tribal inherent jurisdiction. Justice Thomas questions the constitutional basis of Congress's exercise of power in tribal affairs to begin with. And he suggests that the Duro Fix was rather simply a statement of federal policy. Of the political branches, he said, the tribe's exercise of criminal jurisdiction over non-members is simply consistent with federal policy. So Justice Thomas takes the view that this isn't constitutional. This isn't something where the Constitution mandates or requires or allows even Congress to move in that direction. This is simply a question of what is federal policy? And is the tribe's exercise of power consistent with federal policy or inconsistent with it? And at this point he said it's no longer inconsistent with federal policy to allow tribes to exercise that jurisdiction to criminally prosecute and punish non-member Indians. Finally, I want to point to Justice Kennedy's concurring opinion because it's the one that raises the most interesting aspects for me when it comes to federal Indian law. Justice Kennedy concurred, like Justice Thomas, because he doesn't see a double jeopardy bar. That's because the proper occasion to test the legitimacy of the tribe's authority, namely whether Congress had the power what it sought to do, was in the first, the tribal proceeding. And because Lara didn't contest that hearing, it's not properly before the court. I guess the question now is what would happen if an Indian of one tribe, tried by a court of another tribe, contests that inherent jurisdiction under the Duro Fix? Was it conferred or delegated by Congress? Or did Congress merely recognize that it was there all along somehow, even though the court earlier said it wasn't? Instead, Justice Kennedy raises an important point, in my view. He notes the court has affirmed the inherent authority of tribes over its own members. That's clear. Then he says, it is a troubling proposition to say that Congress can relax the restrictions on inherent tribal sovereignty in a way that extends sovereignty beyond those historical limits. He says to conclude that a tribe's inherent sovereignty allows it to exercise jurisdiction over non-members in a criminal case is to enlarge the unique and limited character of tribal inherent sovereignty. He says, Lara, Billy Joe Lara, after all, is a citizen of the United States. To hold that Congress can subject him within our domestic borders, hear that word domestic, to a sovereignty outside the basic structure of the Constitution is a serious step. The Constitution is based on a theory of original and continuing consent of the government. And I looked through as many Justice Kennedy opinions as I could where he referred to the consent of the government, something that's not in the Constitution but in the Declaration. It's not there much. But their consent, he said, depends on the understanding that the Constitution has established a federal structure which grants the citizen the protection of two governments, the nation and the state. You recall my first question, are there three governments in this country, or are there two? Each sovereign must respect the proper sphere of the other, for the citizen has rights and duties as to both. And then he said, contrary to this design, the national government, Congress in this case, seeks to subject a citizen, the non-member Indian, to the criminal jurisdiction of a third entity to be tried for conduct occurring wholly within the territorial borders of the nation and one of the states. Again, he's talking about two sovereignties, not three. And he calls the third one a third entity. And then he says this is unprecedented. There's a historical exception for Indian tribes, he says, but only to the limited extent that a member of a tribe consents to be subjected to the jurisdiction of his own tribe. That's that consent notion. The majority today reaches beyond that limited exception. So Justice Kennedy looks to the individual citizen as having an enforceable right to the structural guarantees of liberty in the Constitution, not just the Bill of Rights, including the consent of the government. He's going to probably continue to have this view as these cases move forward. The Lara case and case law jurisdiction, case law jurisprudence brings us perilously closer to the question raised by Justice Kennedy. Just how far can a tribe go in exercising jurisdiction as if it were a separate state, constrained by a few rules from Congress, but otherwise denying citizens rights that they enjoy under the Constitution of their state and their nation? I would submit that the status quo, which is tribes enjoy sovereignty over their own members, and they have limited sovereignty over others, particularly in the civil context, butting up against state and local jurisdictions in disputes over Indian gaming, environmental protection, land use, and the like. That status quo will just plod along with its edges eroded on occasion and bolstered on occasion. Typically, when adjustments to these jurisdictional questions are offered in the U.S. Senate, they move so far that are blocked by the House. Things that are offered in the House that tend to restrict the tribes may move ahead in the House but get blocked by the Senate. So very little happens in the Congress. When Congress actually passes something that affects tribal jurisdiction, it's very rare indeed. Perhaps Justice Thomas's call for a re-examination of the foundation of Indian law will not be answered, and Justice Kennedy's admonition that individual liberty rights of citizens require protection will go heeded or unheeded by Congress. But federal Indian law will rest increasingly on tenuous and shifting grounds. Chief Justice Marshall split the baby and ensconced a sovereign that is not fully sovereign, nor fully subject to U.S. authority. While that made historical sense at the time, when tribes were generally more separate and remote, albeit neglected, impoverished, and penalized, it seems to me to be increasingly less tenable in today's world. I look forward to answering any of your questions, and thank you very much for having me come today.
Actually, here, we'll go to your comments and then questions.
Pick up the pizza. Jim said it's much for pizza.
In all honesty, it's the most bizarre activity we've ever been involved in, that I'm really fascinated by it. First of all, John said I know absolutely nothing about Indian law. But he asked me to do this yesterday, so over the last 12 hours or so, I've read all that I could do, and I've been a very bad role model for you. I've only read secondary authorities. I've not read the Oliphant case, although I'm about to comment on it now. Exactly what's bizarre about this is I find myself, I believe, if I understand what's going on, agreeing wholeheartedly with Justice Thomas. And those of you who know me, that's a rather peculiar situation for me to be in. And thirdly, I think I find that this is an area where Federalists ought to be particularly comfortable. The notion of more than one sovereign having authority legally over the same territory. But let me start by and I'm borrowing heavily on secondary sources, my understanding of where we are today with respect to Indian tribal sovereignty. And as I understand it, without reading the cases, is that the cases have basically limited tribal power to tribal members, and that basically conceptualizes tribes as private clubs or religious organizations. But my view of sovereignty is entirely different, and that is that sovereigns have power over territory, not over citizens. Ohio has power over everybody in Ohio. Even Mr. Gede, who's a California citizen on his way to Washington. But as long as he is in our jurisdiction, which may be longer than he intended given the weather, Ohio has power over him. Not because he's a citizen of Ohio. He's never been, so far as I know, a citizen of Ohio, never wanted to be a citizen of Ohio. He doesn't know what he's missing. But Ohio, as a sovereign, has power over him. And it seems to me that conceptualizing Indian tribes as private clubs misses the point entirely. Members of clubs or churches can choose to join and choose to leave at any time. Basically, members of clubs or religious organizations can enforce their norms on their members only if those members agree to submit to their authority. But, in my opinion at least, and I've never hesitated to have an opinion if I knew nothing, so I know nothing, but I have an opinion. In my opinion, tribes are not merely clubs, but they are sovereigns. The Supreme Court has said that. A number of scholars have said they are sovereigns. And as Mr. Gede said, domestic dependent nations who never voluntarily relinquish their powers over their territory. Moreover, the treaties and statutes that recognize the reserved rights of tribes implicitly affirm tribal political powers over their retained lands. And this notion that somehow the Constitution doesn't speak to the notion of three sovereigns misses the point entirely. The Constitution does refer to treaties, and in fact, treaties was the word always used to describe the agreements between the federal government and Indian tribes. Didn't use some other word as a contract or a memorandum of understanding or something like that. So it seems to me implicit in the Constitution is the notion that that treaties with Indian tribes take precedence over states' rights, in the sense that the Supremacy Clause, something I do know a little bit about, federal law is supreme with respect to matters of supremacy of treaties and federal law, and the states can't diminish that in any way whatsoever. So it seems to me that despite what the Supreme Court believes, the coerced transfer of property from the tribe to non-Indian owners that occurred in that allotment era during the late 19th century and early 20th century, from I think roughly 1887 to 1934, if I recall right, in no way diminishes tribal power over the lands that were conveyed. So it seems to me that tribal sovereignty remains until it is expressly taken away by Congress. And the Indian Reorganization Act of 1934 repudiated the allotment policy of the late 19th century and early 20th century, and it enacted a policy in support of tribal government. And it seems to me it has been and should be the consistent practice of Congress and certainly every president since 1960 to support tribes' sovereignty. And again, tribes have sovereigns have power over territory, not just citizens. So the oddness of defining sovereignty by reference to citizenship alone, it seems to me, can be seen in the Supreme Court decisions. But it's a position that I find very inconsistent with our notions of federalism and the notion of duality or triality of sovereignty, that it seems to me implicit in the federal government, the Constitution's notion of a supremacy clause that involves treaties being supreme to state law. I would certainly appreciate any correction of anything I said and any questions, but I think those questions should be directed at Mr. Gede, unless you want the flashcard version of Indian law. You want to correct?
Any questions? I would agree with Professor Wilson that Justice Thomas went so far as to say that Congress, trying to exercise its power in 1871 to prohibit the president from entering into treaties with Indian tribes, was inconsistent with the Constitution's grant of power to the president to enter into treaties in the first place. So he rattles off inconsistency after inconsistency in federal Indian law and policy, and tries to pull back, as Justice Thomas often does, pull back to the Constitution. What does the Constitution require? Now, I guess the question about territory is a tough one. In Nevada versus Hicks, Justice O'Connor actually even jumped in and said, wait a minute, tribes exercise authority over their territory, their land, not just over their members, whereas the majority in that opinion referred to the limitations on tribal sovereignty as relating to their members. Justice Kennedy has this notion about consent of the governed, which is, I think, important insofar that because tribes are pre-constitutional, extra-constitutional as sovereigns, then the Constitution and the Bill of Rights don't apply to tribal governments. Congress enacted the Indian Civil Rights Act in 1968, 4 years after the 1964 Civil Rights Act. And it imposes on tribal governments certain of the Bill of Rights, not all of them, but certain of them, so that by statute, the protections of the Bill of Rights are imposed on the tribes. The Bill of Rights, of course, say no state shall. Well, now no tribe shall deprive an individual of certain fundamental rights. And ICRA, the Indian Civil Rights Act, imposes restrictions on tribal government's ability to impose a certain level of a fine and a certain level of an imprisonment on those that they prosecute and punish. Still, the argument is out there that if that were extended either through delegation or a recognition of inherent power of a tribe to punish and prosecute a non-Indian, whether that non-Indian's protections under the Indian Civil Rights Act are comparable to the constitutional protections that that citizen would have in any other state or the federal system. Arguably no, because ICRA doesn't appear to be a mirror image of the Bill of Rights, and the jurisprudence that has developed around it doesn't appear to be the same as the jurisprudence that attaches to the Bill of Rights as it's developed in the federal and state courts. Whether that's enough to deprive a a serious liberty interest of a non-Indian citizen facing a prosecution in a tribal court is for powers above my pay grade. But it certainly would tender constitutional questions that would go back to Justice Kennedy and Justice Thomas, who have latched onto these issues with force the next time it comes around. Russell Means, as you know, was facing potential prosecution in a court of another tribe. So it's, I think, all been resolved separately. But there was a case where he certainly could have contested the ability of the other tribe to exercise its criminal jurisdiction over him, a non-member Indian. An Indian, but not a non-member Indian. After Lara, it's clear Congress and federal policy is such that we recognize an Indian tribe to have that power to prosecute and punish any Indian, regardless of whether he or she is a member or not. The question of territory versus membership actually also tracks the question of consent of the government. If you go to Italy, you've consented to the jurisdiction of Italy, and Italy prosecutes American citizens, as you've seen. But federal jurisprudence has stated that Indian tribes aren't in the same position as Italy, Japan, or Mexico, that they are domestic sovereigns, and that there is an overriding sovereignty of the United States. That's why I started this out saying this is an area that is muddled and not likely to become clear in the future. It is reinvented every time the Supreme Court grapples with it. And since Lara was decided, we now have Justice Sotomayor, we have Justice Kagan, we have Chief Justice Roberts, we have Justice Alito. We have a whole new court in many respects. But Justice Kennedy is still there, and Justice Thomas is still there. And they've sunk their teeth into this a couple times. And so it'll be very interesting to see where it goes. I have to say that of all the 4 new justices and Chief Justice that have gone on the court, I believe Chief Justice Roberts is the only one with any background and experience in federal Indian law, having argued cases in the Supreme Court relating to it. The other 3, I see no real track record or background in this area. And they are from New Jersey, New York, New Jersey, whatever, which are not big Indian states. New York is a big Indian state, I take that back, but Long Island and New York City aren't, even if they were originally. New Jersey doesn't have a lot of Indian jurisprudence. So I'm not sure how schooled the new justices are or will be in these areas. I have full confidence in their ability to jump into these things. But federal Indian law is a convoluted and astonishingly nuanced body of law, and as I said, muddled. Justice Thomas didn't really say that he fully believes that tribes have retained all these powers. He simply said that he wants to skew to the Constitution, recognizes what's constitutional and what's federal policy, and leaves it at that. When a question is tendered that really forthrightly is foursquare on this question, it's hard to say where Justice Thomas actually will be. But no question that he's faithful to his view that the Constitution doesn't dictate all this. The Constitution does mention Indians in a couple of contexts. It provides the Indian Commerce Clause. You may recall, those of you who are aficionados of the Articles of Confederation, that there was an Article 9 in the Articles of Confederation which said that all things Indian will be handled by the Continental, or whatever the Congress was under the Articles of Confederation. Except, it said, in a proviso, whenever the states have already handled it. It's more awkwardly worded than that, but it was a nullity in effect, and James Madison said that it was one of the most bizarre and unworkable features of the Articles of Confederation. That was fixed in the Commerce Clause of the Constitution adopted in 1789, in which, under the Commerce Clause, Congress got the power to regulate commerce, Congress got the power to regulate commerce between the states, with foreign nations, and the Indian tribes. And it's all federal. The states are cut out of the picture. And there was a purpose behind that. Not just what James Madison observed about the Articles of Confederation, but because the states were the principal violators of tribal sovereignty, allowing settlers to infringe on tribal lands and violate tribal rights under the treaties. So it became a federal protected area and not one of the states. Now, that said, the Indian Commerce Clause gives Congress the power to regulate commerce. Justice Thomas says it's a far stretch to go beyond that from commerce. And this kind of goes to our question about Obamacare and other federalism issues. How far does the Commerce Clause go? Well, it's the same question in the Indian Commerce Clause as with the Interstate Commerce Clause, as how far it goes. Is it just about commerce, or is it about regulating all the affairs of ... fill in the blank? And finally, on that point, I would say that Chief Justice Marshall grappled with this too when he looked at the language that James Madison put together, in that it says that Congress has the power to regulate commerce between the states, foreign nations, and the Indian tribes, and observed, well, if Indian tribes are foreign nations, then it would have said foreign nations including the Indian tribes, or foreign nations along with, or as part of, including the Indian tribes. But it enumerated Indian tribes separately from foreign nations. So he had no other conclusion to draw but that the Founding Fathers meant that Indian nations are different than foreign nations. And thus, he engaged in his reasoning that split the baby and said they're neither fully sovereign like foreign nations, nor are they something that is completely without their own nationhood. So again, there's your muddle. It goes back to 1789. It goes back to before 1789, and it's still with us today. I think I'm just responding to Professor Wilson. Are there any questions, please? Yes?
You mentioned this notion of tribal membership, and I know there's sort of this theory of like a blood quanta. Is that something that sort of comes about as a result of federal policy, or is that something that Indian tribes themselves have demarcated and sort of used?
Tribal membership is dependent upon the tribe's determination of what the membership is under their own constitution or policies. The federal government, through the Congress, has enacted a number of laws that provide certain benefits to Indians based on their blood quantum level of Indian blood, including education, housing, and health services, and a whole number of fields. Many of them conflict one with the other, and they may well conflict with the tribe's view of what their tribal membership is. So if you are interested in job opportunities, there is a whole field out there of people who do Indian blood quantum levels, because there are people that fall through the cracks that are, and particularly consider intermarriage between tribal members or Indians who may or may not be tribal members, in which their children may become eligible for membership in two tribes or ineligible for either because they lack the blood quantum level for one, the other, or both. So it's a field ripe with opportunities for busy young lawyers who want to jump into that if you're inclined. But it too is a muddle. If you want to get into the really incendiary questions that touch on all kinds of sensitivities, you go to this, there's a whole other field here that is dynamics that deal with the question of who are peoples and what does the UN Charter on Indigenous Rights say? And is that consistent with or inconsistent with the UN Charter on Individual Rights, on human rights? Are they consistent or inconsistent? Who is a people? Are Indians Indians because they're culturally Indians, or just based on their blood quantum level? Those are difficult questions that touch on everything from civil rights to human rights, and again, above my pay grade. But certainly fascinating. Tribes treat those issues with a great deal of sensitivity, and they demand a great deal of respect. They're not easy. The truth is that the rate of intermarriage between ethnic groups in the United States, or racial groups in the United States, the highest is between Indian and non-Indian, more than Asian American, non-Asian American, African American, non-African American. What that means for the long-term prospect of Indians as a people is anybody's guess, and is maybe a question more for anthropologists and historians than for lawyers. But there are opportunities for lawyers grappling with these difficult questions.
To get back, though, to Alan's question, at least my reading, my understanding is that the quantum blood requirement is a federal government requirement. That, well, actually, one thing I learned, that there are over 560 recognized tribes in this country. I didn't realize that, but that's what I read. But secondly, many tribes, but not all, historically, long before even there were whites, would adopt or allow people who had no blood in that tribe to become members, either through marriage, sometimes through adoption, sometimes the early fur traders were sometimes made members of the tribe even though they didn't marry in and obviously had no blood. So the quantum blood requirement is, I think, exclusively a federal.
Well, the tribe determines membership.
The tribe determines membership, right, yeah. But many don't have any blood requirement. But from a federal government standpoint, to be a tribal member, to get these benefits from descendants, it's almost like being inheriting under a will. You've got to be able to trace yourself back to that great-great-great-great-grandfather some way. So there's got to be a blood quantum in that sense. But it is interesting how it's the federal government that set up this blood requirement in many tribes.
And in Rice versus Cayetano, argued, by the way, by now Chief Justice John Roberts, on behalf of the Office of Hawaiian Affairs, in Hawaii, this whole question of whether they're a tribe and entitled to all the same recognition that tribes in the lower 48 in Alaska are, and which was ultimately rejected by the Supreme Court. The blood quantum level there fell into two categories. The federal government had one requirement as to what a Hawaiian was, and the state had another guideline as to what constituted Hawaiian. One name for one was Native Hawaiian, the name for the other was Hawaiian. One involved any drop of blood from before Captain Cook arrived in the islands would qualify you as Hawaiian. The other one, the other standard states that you have to have 50% or more Hawaiian blood. So it's ripe with inconsistencies and confusion that don't always answer themselves easily. Other questions? This was just a ruse for pizza, right? I mean, that's what I gathered here. It was good pizza, I hope.
Oh.
I have a question about how much different is the tribal court system from the regular state system?
Oh, excellent question. How different are the tribal courts from regular state and federal courts? It depends. It depends on where you are from tribe to tribe. This may differ. Many tribes that are very small don't have their own courts and share with other tribes, tribal judges, to handle these things. Most of them are civil cases and not criminal, so this question of authority to prosecute and punish aren't the big issues. It's usually the civil issues. But as Justice Kennedy pointed points out in his concurrent opinion in Lara, the courts, tribal courts, and actually in Oliphant, back in 1978, then Justice Rehnquist said that the tribal courts today reflect greater sophistication, greater structure and infrastructure than they ever did before. That doesn't seem to be the answer for Justice Kennedy, who is looking for guarantees of protection of all of the constitutional liberties. And a tribal court isn't bound to those. It's bound only to the Indian Civil Rights Act and can develop its own jurisprudence as to what those statutory reflections of the Bill of Rights are as it develops its own jurisprudence. Many tribes join consortiums for their courts of appeal and the like, but they develop a body of what's called tribal law, as to be distinguished from federal Indian law, which is what we've been talking about mostly. Tribal law will differ from tribe to tribe and cover a whole broad range of tribal ordinances and court rulings. But they are more sophisticated than they've ever been. They draw on the state and federal courts for their background and landscape as they move ahead. The truth is that the commission I'm on and the Congress, as it looks at these things, will, once they feel more and more comfortable that tribal courts look like, sound like, and act like state and federal courts, the more they're going to be willing to accept them and accept the jurisdiction of the tribes. Now, that's a terribly paternalistic thing to say. That's suggesting that, oh, once the tribes get to be just like us, the non-tribal world, then yeah, they're fine. We'll grant them all those powers. You have to kind of step back 3 steps to see what's happening with that. It's great that if resources are available and the improvements come as the Department of Justice has worked hard to help tribal courts get established. But you have to look back and say, well, what's happening? In very traditional tribal societies in the American Southwest and Alaska and other places, they don't follow those models. And there should be no reason to suggest that they are somehow lesser than. But, from Washington, D.C., everything, if it's like the federal system, then it must be good. That's the way.
Yeah, this was a tangent that I got off in my research last night, but in part because I already knew quite a bit about, because of my background in alternative dispute resolution, different kinds of Indian dispute resolution mechanisms. First of all, there are 561 tribes, so you can't totally generalize. But to a large degree, many of the tribes have dispute resolution mechanisms or court systems that are very similar to ones that ADR experts have been advocating for a number of years, such as it shouldn't be winner takes all, loser loses all, but there should be attempts to work out resolutions that satisfy the maximum number of interests of each party. And many, but not all, but many of the court systems, which traditional Anglo-American, traditional federal court systems don't like, is that the decider, the arbitrator, the judge may step down and say, let's see if we can't work this out, and serve as a mediator. It plays a role entirely foreign to those of us who are used to a federal judge, say if they're deciding your case one way or the other. Another thing, though, that harks back because of my civil procedure, back in the old days when the jury system was first started at common law, the jurors had to know the parties. That was the fundamental element. You had to know the parties, so you knew, and you had to sometimes actually seen the accident or the horse falling over the person or something like that in order to be a juror. And of course, we've moved away from that now. The less you know, the more likely you are to be selected juror if you know too much. But many of the Indian systems that I was reading about last night have this requirement that whoever's the decision maker has to know not just the parties, but also their clans and their ancestors and go back a long ways. And of course, that's alien. We would disqualify those folks as judges under our traditional American federal court system. So it's hard for me to argue that our system is superior to their system. Their system, it seems to me, is more likely to get a good outcome from a societal standpoint than our winner-take-all judges and juries who know nothing about the parties or about the situation is likely to get. But again, it depends on the lens.
Yeah, and I rather think that's almost not even a question of law. It's a question of political science and philosophy. You know, how a society organizes itself. It goes back to the question I started with, though, is how many sovereigns do we have in this country? 2 or 3? And when you're dealing with the third entity, as Justice Kennedy put it, are we dealing with something greater than or lesser than a sovereign that is respected in its whole? Tough questions, and like I say, the good news is it's muddled, the bad news is that it's muddled. I say good news because it's an opportunity for lawyers. Whenever you hear about things that are muddled, let's go out there and get them. Since are you all third year or second year? How many third year? Okay, second year? First years? Good. Well, you have great opportunities ahead of you.
Yeah, it seems to me especially fitting for a Federal Society gathering, which is that there are multiple sovereigns in this country, and that, because the United States is a federal system, and I think that Federalists of all people ought to be most comfortable with the idea of the recognition that in essence our system is one of multiple sovereigns within overall boundaries. So it seems to me that there is no inherent contradiction between in a Federalist arrangement among multiple sovereigns and multiple layers, and I think that's kind of what Thomas understands, is that
in part, I don't think he's grappled with the trilogy entirely, nor has he, come to what Chief Justice Marshall had to. Indian nations is enumerated separately in the Commerce Clause, and thus the road to finding that they are domestic dependent sovereigns. Every nation that has indigenous peoples, however that's defined, and it's not an easy definition, face these issues, including in the old world as well as the new world. I knew in Japan, the Amanese in India, the Sami in Finland and Norway, they all, and Russia has Siberian peoples, multiple Siberian peoples, all of whom claim certain indigenous rights, as well as, of course, Australia, New Zealand, in that part of the world. But tribalism, and that's a neutral word here, tribalism is calls for a lot of analysis at how it fits into the whole system of multiple governances and polities in the world. Pakistan has Waziristan. Talk about issues about tribal autonomy. What's Pakistan supposed to do? What's Waziristan supposed to do? Tribes want to be left alone. But, you have obvious difficulties. As I also said at the beginning, all the flashpoints here are about the interaction and the interface between the tribal world and the non-tribal world. That's where the flashpoints are. And it's the same in Pakistan as it is here. I mean, clearly it's more serious there in certain ways than here.
All right, with that, unless we have any other questions, we'll probably wrap it up. Please join me in a round of applause for speakers today.